Hello guys, this is Olayeni Dear Kolola Daniels, popularly known as Dear Spectre, and welcome to my channel. Hey guys, this is Olayeni Dear Kolola Daniels, popularly known as Dear Spectre, and this is another episode of Dear Talks Law. And on today's episode of Dear Talks Law, I'll be talking about the nature of equitable interest. But before I move into the business of today, if this is the first time of coming to my channel, then I want to say a very big welcome. Make sure that you click the subscribe button and also click the notification bell so that anytime I release a video, you are going to be one of the first people to watch it. So now, moving into the business of today, basically we are asking ourselves, what is the nature of equitable interest? That is the same as asking, what is equitable interest? Do you understand? Now, it is going to be practically impossible to understand what equitable interest is if we don't in fact know the history of equity. So now I'm going to dedicate another video entirely into the history of equity. But for today's video, we are basically going to be talking about the nature of equitable interest. But I'll be saying one or two things about the history. You are supposed to know as well that before 1873 in England, there was only one type of court, and that is known as the common law courts. Do you understand? That's the common law courts. Now, according to the common law courts, they were very strict in the applicability of their rules. They follow the laws made by the legislature to the letters. If the statute says A, B, C, the common law follows the procedure of A, B, C. Anything outside A, B, C, whether or not it is fair, whether or not it is just, is none of the judge's business. All they care about is that A, B, C has been followed. Do you understand that? Now, because of the rigidity of the common law court in the applicability of the rules, then the Lord Chancellors started, bringing new kind of rules, which they later termed the rules of equity, to water down the harshness of the common law courts. Do you understand? So let me give a particular example. So now, according to the section 4 of Statute of Frauds, it says that when you want to buy a land, when you want to sell a land, when you want to transfer an interest on a land, then that particular thing must be in writing. Do you understand that? Now, if A wants to buy a land from B, B knows that if that thing is not in writing, it's not going to be enforceable in court. Now, B deceives A to give him the money. Do you understand? Let's say he wants to buy the land for 1 million naira, with the promise that when he receives the money, he will give A the land. Do you understand? Now, when A finally gives B the money, B would now say that it is not in writing and therefore it is unenforceable. A will run to court and say, my lord, I transferred 1 million naira to B's account and B doesn't want to give me this land. Then the court will say, the subject matter of this particular contract is land and therefore it is supposed to be in writing. If it is not in writing, then it is unenforceable. Do you understand? So it was due to things like this that the Lord Chancellors brought out what is known as the Court of Equity. So now the Court of Equity will look at that particular instance and say that the statute is not supposed to be used as an engine of fraud. In this case, B knowing fully well that if that transaction is not in writing, then it will not be enforceable by the court. Therefore, B wants to use that same statute of fraud for fraud. Do you understand? Now, the common law court will not look at the fact that B is using it for fraud, but they will just follow what the letters of the statute is saying. Do you understand? Now, the court of equity will say that B knows about this, and yet B still collected the 1 million naira. Therefore, we are going to issue a writ of specific performance. Specific performance is saying that B must perform the terms of the contract. According to the terms of the contract, B is supposed to give the land to A. According to specific performance, the court is going to enforce the contract by compelling B to make sure that he sells the land to A. Do you understand? So that is how the court of equity usually work. Now, it wasn't until the Judicature Act of 1873 to 1875 did they bring the common law court and the court of equity together in one particular court. Do you understand? Prior then, we had the common law court and then we have the court of equity. But now, what we have in our court, even in Nigeria today, is the common law court and the court of equity fused in one particular court. Now, so the question we are going to ask ourselves then is, what exactly is equitable interest? Now, you see those interests that were not enforceable under the common law courts but would be enforceable under the court of equity are what is known as these equitable interests in question. Those interests that were not enforceable under the common law court but that will be enforceable under the court of equity are what is known as these equitable interests in question. Do you understand? Know that these equitable interests are classified into two. The first classification is the kind of equitable interest that is modeled after the common law, while the second kind is that one that came out of equity independently. Now, talking about that model after the common law, I'll be giving just one example. And what example is that? That of the law of trust. Now, if you don't know what law of trust is, I'm going to give you an example on the board. So now, when you have A here, you have B here, and then you have C here. Do you understand? A here is the father, B here is the son, C here is to be the trustee. So now, A is a very, very wealthy man. I want your Dangote. Do you understand? Now, when A was about to die, A realized that, oh, I'm about to die, and I need this particular property to end up with my son. But my son is still 13 years old, and therefore a 13-year-old person cannot hold this particular property. If I should die intestate, that means if I should die without a will, they might share my property in a way that I would not like. Do you understand? Therefore, A then decided to give all his property to C. Now, C is supposed to hold this particular property in trust for B until B becomes 18. Do you understand? Now, when A dies, let's say the estate is about 100 million naira. Now, when A dies, the legal estate of the property then goes to C. Do you understand? And that's what the court is looking at. That's the common law court. The common law court only would be interested in the legal interest. Now, if C sees that, my name is now spending because I have 100 million, and decided to use the property in such a way that will be detrimental to B interest. Do you understand? B cannot go to the common law court and say, my lord, C, who is supposed to hold this estate in trust for me, is using this estate in ways that if I finally have anything left from that estate, it would have depreciated from the 100 million naira that my father left. Do you understand? If C decides to use that property anyhow, using the property and leaves it in a deteriorating condition, B would no longer be able to have the 100 million naira estate that his father left. Do you understand? Now, if B goes to court, the common law court would not recognize B's interest because according to them, the legal estate is vested in C. Do you understand? But according to the court of equity, which came up because of the hardship of the common law, the court of equity says no, C is not even the owner of this estate. The common law court is saying C is the legal owner. The court of equity is saying C is not the legal owner. C is only the custodian of that property till he becomes 18. So according to the eyes of the common law, C might be the legal owner, but let us clothe B with something known as equitable owner. So according to the court of equity, he becomes someone with equitable interest on the property, subject to him being 18 years old. Do you understand how legal interest and equitable interest? The court of equity sees that what A is about to do will be detrimental to B, and it's unconscionable for you to do that to B. It is unfair, it is unjust for you to do it to B. Then the court of equity will want to assist B. Do you understand? According to the common law court, they just see A, they do not even look at B at all. In this place, they just look at C, and then they ask the question, who is the legal owner? C. Before B becomes 18, C remains the legal owner. So therefore, B, you have no rights in front of us, you can move out. That is exactly how, we have the equitable interest. Do you understand? So equitable interest are those rights that would not have ordinarily be enforceable under the common law. Do you understand? Now, the second classes of equitable rights, you have things like the mortgagor's equity of redemption. Do you understand? That's the second class. The first class, I told you they are modeled after the common law. So when the common law has failed, the court of equity will try its best to fill the gap and the hardship of the common law. Do you understand? Now, under the second class here, which is the mortgagor's equity of redemption. Now, when you're talking about that, you know what a mortgage is? When you go to a bank and then you say that you want a loan from the bank, and then you drop your certificates of house to the bank. Now, when you drop that certificate, if you say that I am going to pay on the 1st of June for that particular loan that you have collected, according to the common law, once the 1st of June has passed by 1 minute, do you understand? Once the 1st of June has passed by 1 minute, your property is forfeited, and that is the end. But according to the court of equity, they say mortgage would always be a mortgage. And by that, it means if after 2 days or thereabouts, or after 15 days or thereabouts, the other party who collected the loan now has the money for the loan, he can always go to the bank, drop the money, and get his property. But according to the common law court, that is the end. The moment your 1st of June has passed, that is the end of story. Do you understand? Other types of equitable interest that originated from common law independently include things like restrictive covenants, equitable vendors lien, and all that. But I will be explaining each of them independently in different videos. But just make sure that you understand that equitable rights are those rights that would not have ordinarily been enforced under the common law. Now, we are moving into what exactly, or how exactly would equitable rights now come to play with, legal rights. When we have legal rights battling with equitable rights, how does the both of them, or how would the both of them come to play? How is the legal right, powerful than the equitable right, or the equitable right powerful than the legal right? That's the next question that we are answering. So now, when you are talking about legal interest in relation to equitable interest, there are basically two principles. You must know these two principles at the back of your head, because it's actually very important. If you want to be knowledgeable in equity, so much so, you must always have these two principles at the back of your mind. And the first one is that the legal interest will always take priority over every other interest, whether or not there is notice of that legal interest. Do you understand? That is to say that the legal interest will always be valid against the whole world, and anybody who acquires an interest in that particular property subsequently will have to take his or her interest subject to that particular interest. Do you understand what I'm saying? Okay, now, so let me give a particular example. Now, A is the owner of this particular house. Now, here has a particular, front, and then there's also B. Do you understand? Now, C's house is here. Do you understand? Now, know that this house is so big that C cannot get to his house except he passes the front of A and the front of B to get to his house. Do you understand what I'm saying? So here, this is C's house. Now, because C knows that he cannot get to his house except he passes there, he then signs an agreement, or he then decided to acquire a legal easement. Do you understand? So because C knows that he cannot get into his house, C then decided to acquire a legal easement. And you know that when you are talking about legal easement, which is acquiring an interest in land, you have to be in writing. Do you understand? Now, when C acquired this legal interest, which makes it a legal interest that will take priority. A sold his property to Z, B sold his property to Y. Now, Z and Y acquired these two properties without notice of C's legal interest. Do you understand? Do you understand what I'm saying? Now, there's already an interest rank above, which is an L1. Do you understand? Now, these two people now acquire their property without notice of, C's legal interest. Do you understand? Now, if they do not know of C's legal interest, the C's legal interest will still be ranked above their interest. Why? Because it is a legal interest. Even if they did not have notice. However, if this was an equitable easement, do you understand? This easement was not legal, but only equitable. Do you understand? Then, if they did not have notice of that easement, if they didn't have notice of the easement, then their own will be ranked above the easement. Do you understand? Which means that when they go to court, they can extinguish this easement if they did not have notice of it. However, if they have notice of it, then they will not be able to extinguish it. So the only time equitable rights or equitable interest will take priority is when there is no notice, and whoever acquires that particular property acquires the property as a bona fide purchaser for value without notice of the equitable interest. So if Z and Y are known as the bona fide purchaser of this particular estate for value without notice of this interest, then they can extinguish this interest and say, since I did not know that you had an equitable interest, therefore, your equitable interest is not going to be binding on us. Do you understand what I'm saying? Note that this is a very rough example. I just want you to basically understand how the legal interest will work and how the equitable interest will work. Do you understand? Finally, before I end this video, I want you to get 3 things. What are equitable interests? Equitable interests are those interests that would not otherwise have been enforced under the common law courts, but are enforceable under court of equity. That is before the Judicature Act of 1873 to 1875. That's the first thing I need you to know. The second thing I need you to know, when you are talking about legal interest will always be prioritized far and above every other interest. Do you understand? That get their interest subsequently if they did not have notice of that earlier legal interest. C here would have a legal interest. If C has a legal interest and Z and Y buys this property without notice of this legal interest, they still cannot extinguish this legal interest because it is legal. However, if it is an equitable interest, do you understand? X and Y will be able to extinguish the interest if they were bona fide purchasers of value of this particular property without notice of these interests. Do you understand? They can only extinguish his interest when they are bona fide purchasers of this particular property without notice of C's interest. If this is the case, then they will be ranked far and above their interest. Do you understand that? So those are the 3 things I need you to take out of this particular video. So now the next question we now have to ask ourselves is, what then are we going to refer to as notice? There are 3 types of notice. You have the actual notice, the constructive notice, and then the implied notice. So basically, our question is, what are the kind of notice that these 2 people would have to have that they will say that will not be able to extinguish C's interest? So if they have actual notice of C's interest, if they have constructive notice of C's interest, or if they have implied notice of C's interest, then they will not be able to extinguish it, taking into consideration that C's interest is an equitable interest. Do you understand that? Now, we are going to be discussing actual, constructive, and implied notices in the part 2 and part 3 of this particular session. Do you understand? So make sure that you subscribe, make sure that you click the bell button so that when I release those videos, you'll be able to know that they have been released and you'll be one of the first people to watch it. So thank you very much for watching this particular video. I'm going to see you in my next video. My name is Olayemi Dear Kolola Daniels.